Following the constitution of this tribunal and the selection of its personnel, this case now stands for trial. It is understandable that such delay has occasioned some impatience on the part of the members of the tribunal, but notwithstanding such impatience, they realize and have recognized that in a matter of the magnitude and importance of the action upon which we are entering, aware of the gravity and importance of the issues involved in this case and in others like it. They are aware of the responsibility that rests upon them to ascertain, by the exercise of all the care of which they are capable.
These proceedings at Nuremberg, in which crimes against peace are charged, are vitally important because the principles to be applied here are man's best protection against his own capacity for self-destruction. When we say that aggressive war is a crime, we mean it to exactly the extent to which we are prepared to treat it as criminal in judicial proceedings. Necessary profession, as long as organized force plays an important part in the affairs of men. But it is the true and high purpose of this profession to protect, not to subject. The military art is never to be practiced for its own sake. The death and destruction which the use of arms entails is redeemed and ennobled only when the sword is the guardian and restorer, not the destroyer of peace. But in Germany, the military profession was not merely one among many. The German officer was accorded a very unique and exalted role. A century and a half ago, the Frenchman Mirabeau wrote that Prussia is not a state that possesses an army. It is an army that has conquered a nation. And it is because of the dominant part which military matters have played in the life and thought of Germany ever since the time those words were written, that this 12th and last case before the Nuremberg military tribunals may well prove of greater importance to Germany than any other case heard in this courtroom. In saying this, we by no means mean to depreciate the significance of the issues at stake in other cases which are being argued. But the evidence here is closely related to one of the strongest currents in German thought, which might be aptly entitled Arms and the German. The defendants are charged not only with the unlawful use of war, but also with its abuse. The laws and customs of war, which mitigate its ravages, have never won more than lip loyalty from the German militarists. The German military manual openly scoffs at the Hague Conventions as being derived from humanitarian considerations, which not infrequently degenerate into sentimentality and flabby emotion. The terrible consequences of this ruthless nihilism are not even today fully grasped. Millions of innocent civilians were slaughtered by troops under the command or control of the defendants and their colleagues, not in pursuit of any legitimate military objective, but in furtherance of the basest Nazi racial and social myths. The defendant von Kirchler, for example, as the documents will prove, observed Christmas Day in Russia in 1941 by authorizing the killing of 230 incurable invalids in an asylum at Makayevo. Mr. Justice Oliver Wendell Holmes has observed that in some circumstances a page of history is worth a volume of logic. And we believe that the story of the German army since the First World War, very briefly treated, will do much to illuminate the issues in this case.